Hi, my name is Karen Slusher, and this is Understanding Tort Law. Tort law is essentially based on the legal premise that individuals are liable for the consequences of their own conduct, which makes sense, or lack of conduct, when such actions result in injury to others. In a school or classroom setting, tort law is the most common area of the law that subjects teachers to personal liability. There are two types of tort law. The first is intentional, which includes assault, battery, false imprisonment, and defamation. I think that one's a lot more clear-cut in terms of identifying whether or not a teacher or a school member has committed an intentional tort law. Or there's negligent tort law, which includes four aspects, which is duty, breach, proximate cause, and injury. And I think this one's a little bit tougher to prove and a little bit easier for people to kind of come at schools or specific individuals for a breach of these duties and deem them negligent in their actions. The first example that I looked at for a case was Frame versus Camo. In this case, Camo was a substitute teacher, and he was forced to use excessive force to remove a disruptive student from the classroom. The student refused to leave on his own will after being asked several times, and so then when the substitute teacher stood and essentially fronted Camo when Camo approached the kid to address him to leave, Camo used physical force in that moment to essentially remove the student from this classroom. While the action was definitely considered some sort of excessive force or assault in this case, Camo was found justified in his actions because Frame did enough to provoke him in that instance. And I think that they saw that the action was necessary in order to maintain order in the classroom and to continue facilitating a learning environment. If this were to happen in the school, I think a couple of things. I know substitutes constantly have a difficult time in classrooms just because they don't know the kids. Kids think that they can get away with more in terms of that. Our substitute correspondent, the person who essentially works with the substitutes in our building, is actually very good about establishing practices with our substitutes so that they know what they need to do in order to provide a safe learning environment for themselves and for the students. They're given contact information for other teachers close to them. They're given contact information for security. And so when they're confronted with a situation where they may have to confront a student, they're actually encouraged to contact school security instead to handle the situation. And within our building, school security has a very good reputation with the kids, and the kids are really good about listening to them in those instances. So I think that would be the number one thing for us. If it were to happen in the school, I think the school would definitely be doing what they could to get as many statements from the students in the classroom to support the substitute teacher or to support the student, whichever needed to be done in that case. And then they'd be looking at different policies that need to be put in place to avoid future situations. The next case that I looked at was Flanagan versus Canton, where a PE class was very disruptive. The gym teacher decided to dismiss the kids early to the locker room to deal with one of the disruptive and combative students. And while that happened, there was a fight that broke out in the locker room that caused excessive injury to one of the students. The teacher was held liable in this case because they were saying that there was enough foreseeable danger in this situation that he should have been present during the changing in the locker rooms, that the student's behavior did enough to warrant more supervision. I think if this had happened in our school, I think one of the big things is ensuring, one, that there's always a PE teacher in each of the locker rooms, the boys and the girls, to make sure that behavior is monitored at all times. I also think that the way that the teacher handled the situation in trying to break up the student, it makes sense to me. I would normally try to separate problematic children. Unfortunately, in this case, it would have been more appropriate for him or prudent for him to take the student with him still into the locker room and keep him with him while the other students were in there still changing, just so that he could avoid any possible conflict. The next case that I looked at was Mitchell versus Cedar Rapids Community School District. This one was actually a little bit tough for me to kind of agree with the way that the courts cited, but the school was found negligent because the student, I think mostly because of the student's special needs. The student in question was 14 years old and had a notice relationship with an older student who is also on the spectrum. And the younger student in question decided to essentially kind of lie about her situation and ditch her afternoon class. And the family basically said that because of what happened outside of the school to their daughter, that the school was at fault because they should have done more to essentially protect her from leaving the school grounds. While I completely understand their frustrations, I also think it's tough to ensure that a school is able to monitor every single student at all times to make sure that they're not where they are. If the girl was in as high needs of a situation as she was, she probably should have been monitored at all times, and then thus an adult would have been with her and would have known she was leaving the school. I think in this case, if that's how the community is going to respond when their kids choose to ditch, it's one of those things where you start to have people who are stationed at doors during passing periods so that you can monitor who is coming in and who is coming out. That for special needs kids, that they are moved from one area of the building to the other with supervision. And that you make sure that you're contacting families in a more immediate fashion as to whether or not a student is currently present. I know at our school right now, we actually call parents we have 94-minute block periods. We call parents within 30 minutes of the period starting to let them know if their son or daughter is unexcused from a class. This policy has been in place actually since about 2008 and has definitely changed attendance. It's changed communication with families, but it's very much a clear way for us to make sure that parents know that we actually don't have any idea where their son or daughter may be and that they need to do what they can to get in contact with their kid. I think that policy is actually one of the best policies that we've seen implemented in our school, and it has made a significant change to what we do. The next case was Bryant versus United States, and this is where 3 boys decided to leave their boarding school and essentially run away back to their home. They were in New Mexico, close to the mountains. It caused the boys, when they left, they got caught in a snowstorm and caused them to be lost for 4 days, suffer excessive frostbite, and to all have their legs amputated. When I first read this court case, I couldn't find the boys' ages and was very much in favor of the schools on this side, but the boys were ages 8 through 10. And so once I found that out, it definitely changed my perception on how the schools should have been found liable, which they were ultimately found liable for the injuries that the boys sustained. Essentially, the school was negligent because they missed a half-hour window of when the boys were supervised by the teachers to when they were supervised by the dormitory heads, and that they had their head checks. I think this is a very easy case to essentially make some policy changes within the program to ensure that the students are consistently monitored and that they aren't left unobserved for a period of time. All it takes is either the dormitory head going to meet the kids at the school building where the classes take place and walking them back to the dormitory, or the school teacher to walk the kids to the dormitories to make sure that they get from one place to another. From reading the court case, it seemed like there was some miscommunication about what should happen during that time. And if those kids do get free time during that half hour, that they go from class to the dormitory. And if that's the case, they have the free time, then they just need to have supervision out in the grassy areas or play area in between those 2 buildings. And so it's pretty easy to understand why the school was found negligent in this situation. And then the last case that I saw, I wanted to look at a bullying case just because bullying is still excessively prevalent and to kind of understand what happened. So in this case, it was Davis versus Monroe County Board of Education. And the student in question was continually harassed by another student, addressed school officials, talked to school officials, the parents reached out, talked to school officials, and nothing was essentially done to stop the bullying or to prevent the bullying from future happenings. What I really like about this case is that it determines a 5-part public school liability. that now can be put in place for all schools to kind of look at and see how that impacts the kids. So the first thing, it has to show that the student is a member of a statutorily protected class. So that could be gender, it could be race, it could be a disability. That the peer harassment is based upon the protected class, so that the student doing the harassing is actually harassing somebody for those specific things. That the harassment is severe, pervasive, and objectively offensive. And so being able to show what's being said, what's being done, and how frequently it's happening, I think is really important in this case. And that the school official with authority to address the harassment has actual knowledge. So you have to be able to prove that the school official has knowledge, which in this case, the school official had excessive knowledge of what was taking place, and that the school is deliberately indifferent to the harassment, which in this case, there was no action taken for the student doing the bullying or doing the harassment. I think that this is really important to kind of understand as a school. So if this were to happen in our school, I think there would actually be a lot of education going into the faculty about what this looks like and how to handle bullying and what to do to report it. I think there would also be specific groundwork laid for how to handle bullying within the school and what the punishments are, should be, and have been. I know our school has done work to kind of figure those things out. But this is essentially kind of the basis for bullying court cases at this point. And the last thing I just looked at were just tips for avoiding liability. And I think that this is really important to think about when looking at tort cases. It's important for school officials, for teachers, for anybody working in the school system to understand. The biggest thing is just to exercise common sense. It's important to understand what your responsibilities are and to do that. You should constantly inspect school grounds to make sure that they are safe and that the kids can't access places that they shouldn't be accessing. You should seek guidance in presence of another school official if forced to enact physical discipline. This will help protect you. And then to always document anything taken and to make sure you just adhere to school discipline rules. And that's it for tort cases.